We've all been there. I get it. Everyone gets it. Like, it happens. You don't really know how, but somehow things go awry and we just fall behind. And now your exams are looming and you need all the information as fast as you can. No need to worry. I'm here to help you in your time of need with this Crash Course Cram series. You will learn everything you need to know to ace your constitutional law exam. This episode will focus on the freedom of expression in Australia and Canada, coupled with a comparison between the country's judicial interpretation. Now, let's look at Australia first. In Australia, there is no presence of a Bill or Charter of Rights. Rather, there are express rights in the Constitution and implied rights that the High Court has held to be enshrined within the Constitution. There is no freedom of expression in Australia. In fact, it has less protection than most other Western countries. However, the High Court has held in landmark cases of ACTV and Commonwealth and Nationwide News and Wills that there is an implied freedom of political communication. This decision was founded upon Section 7, 24, 64, and 128 of the Constitution, which creates representative government. It specifies that the Senate and the House of Representatives must be directly chosen by the people. As this phrase indicates that people have a choice, they must be free to discuss the respective candidates and their policies. Without this right, discussions like these would be impossible and, in fact, illegal. However, the right is not absolute, as it only includes communication on political matters, but not all types of speech. Political communication includes discussion of government policy or debate on the performance of public officials. In Levy and Victoria, the High Court accepted that actions can amount to communication, which extended the types of communication that are protected to both verbal and non-verbal. The initial test to determine the validity of a law was developed in Lange and Australian Broadcasting Corporation, which specified 1. Does the law burden freedom of communication about government or political matters? 2. If the law effectively burdens that freedom, is the law reasonably appropriate and adapted to serve a legitimate end compatible with representative government? However, this was recently modified in 2015 in McCloy and New South Wales, which adopted a more structured approach. This created a threefold test of 1. Does the law effectively burden the freedom in terms of operation or effect? If no, the law does not exceed the limitation and the law is valid. 2. If yes to 1, are the purposes of the law and the means adopted to achieve that purpose legitimate in the sense that they are compatible with representative government? This is considered to be a compatibility test, and recognised legitimate ends are 1. Public safety in Levy and Victoria, public order in Coleman and Power, road safety in AGSA and Adelaide, and crime prevention in Tajur. If not, then the law does exceed the limitation and the law is invalid. If yes, is the law reasonably appropriate and adapted to advance the legitimate object? This is considered to be a proportionality test to determine whether the restriction would be justified. It considers the suitability, the necessary, and the adequate in its balance of the law to determine this balancing test. The fact that the law infringes upon the freedom does not necessarily mean the law is invalid. It must breach the second and or third limb of the test to be constitutionally invalid. In Canada, Section 2B of the Canadian Charter of Rights and Freedoms, which is included in Canada's Constitution, establishes the right to freedom of expression. It states that everyone is entitled to certain fundamental freedoms, including freedom of thought, belief, opinion, and expression, which includes the freedom of the press and other media communication. Expression includes both content and form. Content is the meaning that is portrayed in the expressive activity, and these expressive activities can come in an array of forms. It is not limited to just the things people say. It can include physical gestures, music, and oddly enough, even silence, if it conveys a meaning. Additionally, Section 1 of the Charter places a limitation on freedom of expression where it establishes that reasonable limits can be imposed if prescribed by the law and can be justified in a free and democratic society. Thus, the right is not absolute and can be limited, which is analogous to the concept in Australia. The Constitution is the supreme law in Canada, and all other laws must be consistent, and if not, may be held to be invalid. Once again, this is parallel to the interpretation of Australia's Constitution. It has been acknowledged in Irwin Toy Limited and Quebec and Ford and Quebec that the fundamental principle of upholding the right is to promote the search and attainment of the truth, participation in social and political decision making, and the opportunity for individual fulfillment through expression. Further, there is rationale that it allows for the open exchange of ideas to foster self-actualization and human dignity. The Canadian right is far more expansive than Australia's limited criteria of only political communication. The Supreme Court has determined a three-part test to analyse the freedom of expression. 1. Does the activity in question have expressive content, thereby bringing it within Section 2B protection? 2. Does the method or location of this expression remove that protection? And 3. If the expression is protected by Section 2B, does the government action in question infringe that protection in either purpose or effect? With regard to media communication, broadcasting is governed by the Broadcasting Act 1991, and the Act prohibits broadcasting false or misleading news and abusive comments that are likely to expose persons to hatred based on listed grounds. Now that you understand the basics of each right in Canada and Australia, we're going to look and compare the similarities and differences of the judicial interpretation of what constitutes a reasonable limitation. In Canada, the Supreme Courts have interpreted Section 2B very broadly, which often lends to finding a prima facie breach of the freedom. In Canada Broadcasting Corp and Canada, the Canadian Rules of Criminal Procedure allow the broadcasting, the recording of a hearing. However, this does not include to broadcasting a video recording of a statement entered into evidence before trial. Exhibiting these types of videos is at the discretion of the judge, which is allowed based on a balancing test of freedom of speech, open courts, and administration of justice. Canadian Broadcasting Corporation argued that they should have the ability to film, take photos, and conduct interviews in public areas of courthouses, and further, they should be allowed to broadcast official video recordings of court proceedings, as journalists were allowed to view the film, but denied by the trial judge to broadcast the recording. It was submitted that the rules under Section 38.1 and 38.2 of the Rules and Practices Superior Court Civil and Section 8 and 8B of the Criminal Equivalent, and further Directive A10, infringe the freedom of the press and should have no force or effect. The court held that the activities were not protected under Section 2B of the Charter, as the disputed measures fell into the scope of the reasonable limitations of Section 1. It was stated that freedom of expression does not give the media an unrestricted right to conduct interviews, film, and take photographs inside courthouses. Although broadcasting hearings was held to be a method of expression, it undermines the aforementioned values that underpin the right. It was identified that there must be a rational connection between the means used and the legislature's objective. By allowing the activity, it would increase the number of journalists and the sophistication of technology used in the courtroom and would have adverse consequences far more significant than the objective of the administration of justice. It was stressed that it is essential to protect witnesses, have the ability to move freely without being pursued by the media, and protect privacy. In the Oakes balancing test, it was held that the positive improvement of media interest and engagement, which regardless would not improve the media's ability to describe, analyse, or comment on issues, was not significant to undermine the judicial process guaranteed in the open court principle and thus a justifiable reasonable limit under Section 1. The constitutionality of the rules of practice and of Directive A10 were confirmed. Conversely, in Australia, there is not freedom of expression, but rather political communication. However, both countries have restrictions on the relative freedoms if it is justified on reasonable grounds. We're going to focus on the case of Levy and Victoria relating to what is recognised as a reasonable restriction in Australia. Under the regulations of the Victorian Wildlife Act 1975 and the Conservation Forests and Lands Act 1987, it was an offence to be in an area utilised for hunting game birds at the beginning of the hunting season without possessing a licence. Lawrence Levy, an opponent to duck shooting in Victoria, contravened the regulation 5(1)(a) and entered the area. He argued he was there to draw media attention and ensure people could form or exercise informed political judgments regarding duck shooting. The High Court held that the showing of pictures constituted a freedom of political communication and satisfied the first limb of the Lange test. However, the issue was whether the regulations infringed the freedom. The legislation was for the purpose to ensure public safety and thus a comparable issue to Canadian Broadcasting Corporation, where the media transparency was subordinate to public interest. Here, the question was whether the showing of images of maimed animals was sufficient to outweigh public safety. Although the facts were vastly different in the cases, the process of determining whether a restriction is justified is similar between the countries, as it is a balancing test of competing interests. It was generally accepted that the reasonably appropriate and generally adapted test was relevant. When applied, it was held that the purpose of keeping protesters out of hunting areas at times is not consistent with the purpose of ensuring a greater degree of human safety. Consequently, it was appropriate and adapted to serve the legitimate end of ensuring the safety of persons with conflicting aims likely to be present in the vicinity. Thus, public safety is a recognised category with a legitimate end in Australia. Both countries' restrictions can only be applied if prescribed by the law and the nature of the test is similar. However, a distinct difference is that in Canada, the restrictions are entrenched in Section 1 of their constitution, whereas in Australia, it is developed by common law. Further, as mentioned, there are recognised categories in Australia, whereas in Canada, there is none. It has been stated by the Supreme Canadian Courts that limitations on political speech are the hardest to justify in comparison to cases relating to hate speech, pornography, and marketing harmful products, which have a significantly lower standard. That concludes the analysis of judicial interpretation of freedom of expression in Australia and Canada. We have now completed my crash course on freedom of expression. I have given you all the information and tools you need to succeed in your exam. If you have any questions, please don't hesitate to ask. Good luck and keep a lookout for tomorrow's episode. For your reference, all cases mentioned and sources used in this presentation are cited in the following bibliography slides. See you later.